Hey guys, I'm in Alberta right now because February 25th and 26th, the Alberta court will be hearing our case challenging a law in Calgary that bans protests and restricts free speech on the basis of the content of that speech. The City of Calgary wants to be able to dictate what topics you're allowed to protest about near libraries and community centers and what topics are off limits. The name of this law is so Orwellian. It's called the Safe and Inclusive Bylaw. And as soon as it was proposed and passed in March of 2023, we at the Canadian Constitution Foundation moved to challenge it. We filed a judicial review challenging the constitutionality of this law. And unfortunately, the first hearing date that we could get was not until now, February of 2025. And now that we are up against this hearing date, the city is doing everything that they possibly can to get out of this hearing, including hiring a so-called expert about how people can be offended by certain speech, and so it must be silenced and prohibited. This is so insane to me. You cannot be an expert in being offended. I don't care what this guy's credentials are. So we are fighting the city not to admit this so-called expert's report. It's a pretty fun story, and I can't wait to tell you all about it. If you're new here, welcome. My name is Christine, and I'm the litigation director at the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing legal cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember, nothing in my videos is ever legal advice. If you have your own legal question or problem, please consult your own lawyer. So I want to tell you about what's happening in our case challenging this law in Calgary. Calgary has this extremely progressive mayor, Mayor Gondek, and the city has been running a program called Reading with Royalty, where they had drag queens read stories to children at libraries. They also adopted a policy for change rooms at community centers where people could use the change room of their choice that best aligned with their gender identity, and that they could make the selection on the basis of self-identification. They could decide for themselves which bathroom matches their identity. So both of these things upset some people, and so there were some protests about both of these issues, the change room policy and the drag story hour program. Now, as I've said before in previous videos, you can think whatever you want about these issues. Look, I personally would not take my child to a drag story hour, and I also do understand why people are concerned about the change room policy. The fact is that we live in a Western democratic society, and people will do things and say things we disagree with, whether it's the policies or whether it's protesting those policies. And we are permitted to express our disagreement or disapproval of government policies. That's actually the very core of the right to democratic free expression. If politicians could ban people from expressing disapproval with the things that they are doing, that the government is doing, we would cease to have any freedom very, very quickly. And there are many, many countries around the world where you are not allowed to express disapproval of a government policy. And I don't want to live in one of those places, and I don't want Canada to become one. So that's my concern with what Calgary did with this safe and inclusive bylaw. They did not like people protesting the drag events or protesting the change room policy, so they banned those types of protests. They created this safe and inclusive bylaw where if you protest on certain topics, like those ones, you can get fined or even sent to jail. They created a zone, a bubble around libraries and community centers of 100 meters. And if you protest within that zone, which extends really far, it extends down the streets of these facilities and into residential communities. Well, if you protest in that large zone, you can be subject to that really high penalty. And they created this law even though, for example, if you burst into an event and disrupted it and yelled at people, you could be cited for trespassing and removed. You could be removed for causing a disturbance, or if you were violent, you could be subject to criminal charges. The safe and inclusive bylaw that creates this bubble down the street and into residential communities where you're not allowed to protest is completely unnecessary given all of these tools like trespassing, criminal law, rules related to causing a disturbance. The police already have all of this at their disposal. The city doesn't need this safe and inclusive bylaw. And what makes this law so bad is that it's on the basis of the subject matter of the protest. So you could protest climate change or about a labor dispute, but not about these particular government policies that the safe and inclusive bylaw prohibits. Those are statements that, quote, express objection or disapproval towards an idea or action related to race, religious belief, color, gender, gender identity, gender expression, physical disability, mental disability, age, ancestry, place of origin, marital status, source of income, family status, or sexual orientation. Those are the banned topics you're not allowed to protest about if your protest expresses objection or disapproval related to those topics. Now, free speech is protected under the Charter, and it is a content-neutral right. It doesn't matter if the thing you are expressing is objectionable or offensive. In fact, if you only had the right to express unobjectionable and inoffensive things, the right to free speech would have no meaning whatsoever. No one would want to silence unobjectionable speech. So on this, the City of Calgary is just toast. The law banning protests clearly violates the right to freedom of expression. But of course, as if you watch this channel, you'll know under our charter, rights can be limited under Section 1 when that limit can be demonstrably justified in a free and democratic society. So that's where this new development comes in that I want to talk to you about today. So even though we filed this challenge back in 2023 and the city has had 2 years to get ready, just a few weeks ago in January, they told us that they wanted to include expert evidence in this case. And this is insane to me. You can't be an expert in this. And this expert that they've called is a sitting parliamentarian. His name is Christopher Wells, and he has a PhD from the Alberta Teachers College. He filed an expert report about things like microaggressions and the psychological harm that could be caused to 2S LGBTQIA plus people by exposing them to anti-2S LGBTQIA plus speech or signs or messaging. And he doesn't actually even define what anti-2S LGBTQIA plus speech is. So I don't know, would holding a sign that says drag isn't for kids be anti-2S LGBTQIA plus? I don't know. He doesn't define the term in his report. His report also cites a number of sources, and that those sources include news articles from CBC. That is not properly sourced and cited in my view. But the bigger problem is at its core, this law is about prohibiting speech that expresses disagreement or disapproval about certain ideas. It's about people being offended. And you just can't be an expert in being offended, even though I'm sure this guy is offended all the time. The idea that the city hired an expert in this case is just ludicrous. So we have objected to allowing the Wells so-called expert report being admitted in this case. We say that it is doubly inadmissible. First, it wasn't before the city when they created this law. They didn't have this report. So his evidence is neither necessary nor relevant. He makes claims about hate crime incidents, hate crime statistics, and hate extremist groups, but there's no evidence of these acts or groups being involved in the libraries and recreational facility protests leading up to the enactment of this law. The Wells report also seeks to import harm from being exposed to the views of others, including an individual's purely subjective interpretation that something is disapproving or objectionable, irrespective of intentionality of the source. So it wants to include the idea that you can be harmed by being exposed to someone else's opinion, even if your experience is completely subjective and the person speaking didn't mean to cause you harm. That's the whole idea of a microaggression. Now, it is obviously trait law that Canada already prohibits hate crimes and doesn't deal with things that are trifles. No one in Canada has the right to not be offended. Notably, there's a Supreme Court case called Whatcott, which we actually intervened in, where the court affirmed that prohibiting any representation which ridicules, belittles, or otherwise affronts the dignity of protected groups could capture a great deal of expression, which, while offensive to most people, falls short of exposing its target group to the extreme detestation and vilification under hate speech, which risks provoking discriminatory activities against that group. So being offended isn't enough. Now, more recently, there was another case at the Supreme Court called Ward, which we also intervened in, where the court specifically reiterated that the determination of whether expression undermines the equal exercise of the right to dignity is objectively determined as opposed to purely subjective. And the Wells expert report simply doesn't fit with all of the recent and binding Supreme Court Canadian legal conventions and precedents. Any suggestion that this evidence is necessary or relevant within the existing legal framework is just wrong. Now, the Wells expert report also contains this idea about the potential harmful impacts of exposure to that anti-2S LGBTQIA plus speech, signs, and messaging. But this evidence is speculative and vague. Specifically, Wells gives this opinion that the exposure to this type of speech, signage, and messaging can have detrimental effects. Now, certainly anything is possible, but Wells doesn't provide any evidence about the likelihood of detrimental effects, and the term isn't defined. The anti-2S LGBTQIA plus term, we don't even know what that means based on his report. There are lots of examples of speech that might offend Dr. Wells, but might not offend many other people, and it's very subjective what people will be offended by. And we don't want to give people jail sentences and huge fines on the basis of what might offend some person potentially. From a 10,000 foot view, it's difficult to reconcile how the Wells expert report has any logical connection to the facts in this case, which speaks to the relevance of the evidence, or how it helps disprove any facts that are at issue here, which speaks to its probative value, its value in this litigation. Now, from the point of view of expert evidence, we at the CCF object to both the qualification and the evidence of Wells. The city can't meet the threshold for qualifying him as an expert, even if it does, the opinion isn't relevant or necessary, as I explained. So it's entitled to be given almost no weight or no weight by the court. So as I said, Wells' education is in teaching. He's not a psychologist, psychiatrist, or physician. He has no formal education in those fields, yet his expert report specifically sets out psychological harms that he claims relate to the exposure to anti-2S LGBTQIA plus speech, sign, and messaging. His proposed evidence is that of what we refer to as an expert at large. It's overreaching. His report is rife with conclusions and opinions cited to fields he's not qualified in, including statistical analysis, psychology, physiology, hate crimes, and extremist ideology. We cross-examined Wells, and that cross-examination revealed that the academic and news articles that he cites in his expert report suffer from the biases associated with having an ideological perspective, and some of these papers and news articles were not peer-reviewed, some had no author at all, and some were not properly sourced. The studies that he is trying to rely on are largely comprised of self-selecting cross-sectional surveys. They're dated. Some of them are, I think, 10 years old. They're not applicable to the issues in this case. And all the studies contain significant limitations that were not disclosed in the sources themselves, or if they were disclosed in these papers and studies, they weren't reflected in Wells' report. Many of these studies, including those related to the experiences of trans people, specifically set out that they were engaged in exploratory and new areas of study, and that more research on the subject is required. This was also not disclosed in his expert report. So to that end, we say that his expert report and the conclusions in it are fundamentally flawed and they're misleading. Now, on top of all of those problems, Wells is an advocate for the expansion of 2S LGBTQIA plus rights, which is fine, but it means he really has a strong perspective. And he's also a sitting federal senator who was recommended by Prime Minister Justin Trudeau and supports the federal 2S LGBTQI plus action plan. And he regularly takes partisan positions when voting on laws as part of his job as a senator. He's publicly advocated for constitutional challenges to Danielle Smith, the Premier of Alberta, her gender-based laws. But perhaps most significantly of all of this, on May 4th of 2023, when this Calgary law was first passed, he not only publicly advocated for the law, he specifically opined in an op-ed that it was constitutional. He has this op-ed where he wrote, "Ask your elected officials to enact legislation that protects the safety, health, and well-being of LGBTQ communities. Calgary's new safe and inclusive bylaw provides an excellent example of how to balance freedom of speech and the right of assembly with community safety and civic participation." Now, when we cross-examined him, Wells admitted that passage could be interpreted as a call to action to the public. He had admitted that he did not disclose to the City of Calgary that he'd made that public statement prior to being retained as an expert. And the statement predates his retainer and his report in this case and in another case about this bylaw. He didn't disclose to the court, either in this case or in the previous case, that he made this public statement. And when we cross-examined him on whether his public statement about the law reflects the position of the city in this litigation, which it obviously does, he said that he couldn't speak for the city's position. I mean, a dubious answer given that the city retained him in this litigation. And when we cross-examined about whether he still held this view that the law is constitutional, he repeatedly did not answer that specific question. Now, respectfully, Wells' public statement about the Calgary protest law in the media and his response to us in cross-examination, it raises the realistic concern that his evidence should not be received due to bias. Now, when you're hired as an expert in litigation, you need to swear this duty as of an expert that you are neutral and nonpartisan. And I just don't think there's any possible way that this could be a neutral person. His lack of disclosure of this public statement in this op-ed to both the city prior to being retained and to the court in his expert report, along with his evasiveness when we were questioning, demonstrates that he's unable or unwilling to comply with his duty to the court. And any reasonably informed member of the public would question the appearance of fairness in this litigation if the Wells evidence is received under these circumstances. The situation is basically analogous to if there's a murder trial and the government retains a forensic pathologist who's publicly commented that the accused is guilty of murder, and then he's hired by the Crown to provide an opinion about the accused in that murder trial. Like, you already know that this pathologist has a position and it's not neutral evidence. He's already made all these public statements that the accused is guilty. You shouldn't retain him to do the pathology report. So we have asked for the court, and this is all sort of established in how the duty of the expert is to be neutral. And just, I think that you can't make the case that this Wells evidence is neutral. So we've asked for the court to exercise its discretion and not include the report from Wells. The city wanted to include it to show that the bylaw was a reasonable limit on the right to free expression. And the onus is on the city to show that the limit is justified. And if the Wells report is all they've got, it's not much. And I don't think that they should even be allowed to have that. Now, we're going to find out on the first day of the two-day hearing, February 25th, if the Wells evidence is going to be allowed in. And I'm going to be in court. I'm going to be posting live on X about everything that happens. And I'll also be doing a live summary after court on the evening of the 25th and the 26th. So if you want my live recap, be sure that you're subscribed to the channel. You have to click subscribe below and then ring the notification bell. And then you will get a notification when I am going live. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.